Hello, welcome to Law Minstrel. I am Nwesi Modukbe Nyim. Today we'll begin a series on legal concepts that are relevant to nursing and the nurse's role. Nursing, and indeed every other profession the world over, is governed by law. There is hardly any profession that does not have legal guidelines within which it's supposed to be run legally. And nursing, an offshoot of the medical profession, is not an exemption at all. It is against this background that the study of law as to how it influences the nurses' delivery of their services becomes relevant. There are quite a number of legal concepts that are relevant to nursing. In this series, we'll be examining 6 of them. But for this episode, we'll begin from the very foundation. And that foundation is actually law as a concept that is relevant to nursing profession and the nurse's role. What is law? Let me just pause here and crave your indulgence to, as usual, subscribe to our channel, share this channel to persons you feel would need it. Communicate with us by commenting in the comment section and give us a feedback on what you want us to be doing on the channel. I personally would want to know what professional you are, what field of study you are engaged in, or what type of practice professionally you are engaged with, and how the law affects that profession, or how the law guides the practice of that profession. But for me, on this episode, I'm examining the law as a concept relevant to the nursing profession. And I'm beginning this by examining what the law is. There is actually hardly any legal concept that has a definition to end all definitions thereof. And the law itself as a concept also does not have a definition that ends all definitions of law. Unlike when you take a foray into other professions like economics, you have a standard definition that ends all definitions of economics. But for law, there is no such definition that ends all definitions of law. As a matter of fact, A.O. Okuniga is reputed to have said, "No one, including the lawyer, has ever offered. No one, including the lawyer, is offering, and no one, including the lawyer, would ever be able to offer a definition to end all definitions of the law." Be that as it may, we will make an effort in defining or describing what the law is. The law has been defined by J.A. Holland and J.S. Webb in Learning Legal Rules, their book Learning Legal Rules, as a rule or body of rules made by institutions, bodies, and persons vested with the power to make such rules which are binding and enforced among the members of a given society or state. Cambridge Online Dictionary has also defined the law as a rule, usually made by a government, that is used to order the way in which a society behaves. Again, law has been defined as a regime that regulates human activities and relations through systematic application of force of politically organized society or through social pressure backed by force in such a society. And this definition is given by Chris C. Wigwe in his book Jurisprudence and Legal Theory, second edition, published in 2024. Now, even though there are a plethora of definitions of law, some given by writers, some by jurists, some derived from case law, and none of this ends the definition of law. It is, however, pertinent that any working definition that you would intend to use to represent what the law is should have some set of features, and we will look at this set of features that should reflect in your definition of the law. We are taking particular look at 6 features, and the first is that the law is a body of rules. The second is that the law is made by man. It is man-made. The third is that the law possesses a normative nature. The fourth is that the law possesses an element of coercion. The fifth is that the law has territorial jurisdiction. And finally, that the law is dynamic in nature. We thus move to the functions the law is supposed to fulfill, because the law is not made in vacuum, it's not made in vacuum, it's not made without any purpose in mind. It's made to fulfill certain societal purposes, and we will now take a look at those purposes. The first is that it defines and regulates social relations. The law is made for the definition and regulation of social relations. So you will see that it is the law that defines and regulates the various forms of social relations that man can engage in, and which therefore exists in human society. One of such relations, for instance, is the family. So the law regulates the social relations of a family. How does the law do this? The law regulates how a family may be formed. The law regulates the parties that can enter into marriage, which is the foundation of a family, a traditional family at least. The law also regulates how members of that family relates to each other, that is, relate one to another, relate inter se, and how members of a family relate to third parties who are not members of that family. These relations or social relations don't end only on family. We have only used family as an example. Generally, the law regulates any form of human relations you can imagine, you can think about, whether it is employer-employee, whether it is mere friendship, whether it is business relations, whatever relations at all you think about, the law regulates how to engage in them, and engage in them lawfully or legally. The second is that the law regulates human behavior. It is the law that sets standard as touching what is acceptable conduct amongst human persons or in the society generally. By doing this, the law controls human behavior and sets boundaries for whatever human actions that you can imagine. So this serves to curtail or deter harmful behavior and in turn promote social order. The third function of the law we are looking at is resolving disputes. The law sets mechanism in place for human beings to resolve their disputes. This is because as humans interact in whatever form of societal relationship, disputes may arise. Even amongst family members, when they interact inter se, disputes may arise, and that is why between even husbands and wives we have what is called matrimonial causes, that is disputes within the marriage. So whatever human relations you think about, in the hospital you have disputes between patients and their health care delivery systems. You have such conflicts, and when they arise, the law makes provisions for systems that can resolve this conflict. This is because human conflicts must be resolved for human relations to perpetuate. If human conflicts are not resolved, then human relations cannot be perpetuated. It is for this reason that the law devises methods by which conflicts may be resolved. So you will see that most professions have disciplinary committees or councils that resolve conflicts within such professions. Then you also have the courts that you can go to resolve your dispute. And there are also other systems that are outside the courts that are called alternative dispute resolution systems that you can engage to resolve disputes. All of these are methods that the law has devised in order to fulfill her function as a dispute resolving entity. Another function of the law that we'll be looking at is the protection of rights and liberties. The law makes provision for the safeguard of fundamental rights and freedoms. Actually, it is also the law that even makes provisions for fundamental rights and liberties. The law does not only make provision for these fundamental rights and liberties, the law also makes provisions for their protection. These liberties include the right to life, the right to personal liberty, the right to association, the right to speech, and the right to fair hearing, and several other such rights. It is the law that creates them. It is the law that sets a system for the protection thereof. And another function of the law, and the final one we'll be looking at, is providing a framework for transactions. Whatever transactions you'll be looking at, whether commercial transaction and so on, the law makes provisions for how they can be carried out. Law regulates business transaction, and the law does this by way of creating a framework within which commercial transaction or commercial activities may be carried out. In this wise, the law facilitates and governs business transactions, property ownerships, contract, and other economic activities. Having examined the function of the law, we'll now be looking at the relationship between law and morality. There is an age-long debate that the law is different from morality, and that the morality and the law do not intermix at all. Actually, there are some things that are morally right, but they are not laws. And there are some laws that offend your morality, but they are laws. So something may be right in the realm of morals, but may not be a law. And something may be wrong in the realm of morals, but may be a law. If it's not a law in your jurisdiction, may be a law in another jurisdiction. But interestingly, from the very beginning, before law became codified in the manner we see today, people were initially governed by moral value system. Their understanding of what is right or what is wrong governed their behavior and the choices that they made. But as the law became codified in jurisdictions, this codification did not cover all that is morally acceptable. And some things that are actually morally abhorrent have come to be codified and enacted in houses that have the power so to do as laws. So, we'll look at the distinction between law and morality. First of all, morality is concerned with the individual and the formation of human character. On the other hand, the law concentrates mainly on the society and lays down rules concerning the relationships of individuals with each other and with the state. Again, while morality is concerned with the mind behind human actions or behind human inactions, in other words, it looks to the motive. Law is concerned with the conduct of the individual for which it lays down standards. Again, while morals are an end in themselves and should be followed as being intrinsically good, law is for the purpose of convenience and expediency, and its chief aim is to help the smooth running of the society. Again, while the observance of morals may be a matter of individual conscience, law is accompanied by an element of coercion from the state or from the sovereign. So it's not about whether your conscience allows you so to do or not. Once it is a law, there is an element of coercion usually emanating from the state that backs up the law. Further still, while morals are considered to be of universal value, law is relative, that is related to the time and the place, and therefore it varies from one society to the other. In more formal terms, it is relative to jurisdiction. Finally, law and morals differ in their application. The morals are applied taking into consideration the individual cases, whereas the application of law is uniform. In sum, in spite of the distinction that is made between law and morality, as if that difference is cast in stone, it is not the case that the two concepts are at variance. Law and morality are not diametrically opposed. They have as though they do not have any point of convergence. The two are in fact mutually compatible and complementary more often than not. There are symbioses that exist in the relationship between law and morality. And this is the reason why sometimes when law is at variance with people's morality, they find it very offensive, because there is something quietly telling the human person that law should follow morality. This debate will be a debate that may never end, because there are those from the school that we want them never to converge. But there is a certain scholar who said, if you keep 10 people in 10 different rooms and ask each of them in 10 different languages which they understand whether it is good to steal, they will tell you in the language they understand that it is not good to steal. So there is something innate in man that wants the law to align with human morality. So law and morality have a meeting point, and these meeting points are seen in three issues. One, that morality is the basis of the law. Two, that morality is the test of positive law. And thirdly, that morality actually is the end of the law. In other words, the law is not an end in itself. At the heart of the law, the end that the law seeks is actually morality. So we'll now look at sources of the law, after which we'll wrap up this episode on the law as a concept relevant to nursing. Basically, the topic or the subtopic sources of the law is bifurcated into two. That is, the sources of the law are just, we're broadly classifying them into two, and these are primary sources and secondary sources. What are the primary sources of the law? The primary sources of the law for most Commonwealth nations, the first is the received English law. The received English law, most nations that were colonized by the British Empire received the common law, the English law. In Nigeria, it is no different. And the English law is made up of common law as well as equity. The second is legislation or statutory law. And this is a law that is made by the state houses that are authorized so to do. The third is delegated or subsidiary legislation. This delegated legislation is, as the name implies, it is legislation that is made by persons that their primary function is not to make law, but they have only been delegated, either most times by statute. There is a statute that delegates them, in other words, authorizes them to make a law on that particular issue. The next we'll be looking at, as the fourth, is customary law. In Nigeria, for instance, that is examined as Nigerian customary law, which is made up of the customs of the ethnic groups that are in Nigeria, as well as the Islamic or Muslim law. The next is international law, which is to be found in agreements of nations like treaties. So this is made up of agreements, rules and norms governing relationship between nations. So although most nations, even when they enter into a treaty, that treaty must be domesticated within their nation or within their jurisdiction before it will become enforceable. We'll finally look at the secondary sources of law and then wrap it up on this episode. Secondary sources of law include law reports, law texts, books, treatises, periodicals, journals, and legal digests. With that, we've come to the end of this episode, which is on law as a concept relevant to nursing and the nurse's role. Let's have a brief recap of all that we looked at. We examined law as a concept, and in so doing, we looked at the definition of law. After that, we looked at the functions that the law is supposed to carry out, since it is not made in vacuum but made in order to fulfill certain functions for the society. After that, we examined the relationship between law and morality. Then we took a look at the sources of the law, which we bifurcated into primary and secondary sources of the law. Thank you very much for staying with us on this episode. I am always Nwesi Modupe Nyim. We are examining in this series the relevance of law to nursing. You are not a nurse, you are in a profession. Let me hear from you how your own career is regulated by the law, or how the law has impacted on your profession and the way you discharge your duties as a professional. Let me hear from you in the comment section. You are not a subscriber? What are you waiting for? Kindly click on the subscribe button and be a member of your community. You can do that for me, and then share with your loved ones, your colleagues, share our videos, and just hit on the like button. Till next time, thank you.